Welcome to our three-part podcast series on global climate change and U.S. law. This is a comprehensive volume about exactly what the title says, all of U.S. law and regulation related to climate change, which is co-edited by Michael Gerrard, me, Jody Freedman, and Mike Berger. We wanted to do a three-part series on the book to give people a flavor of its expansive coverage and the very different and interesting chapters that we've included in this third edition. So let me start our three-part series with a bit of background on how the book came together. And the best way to do that is to ask Mike Gerrard, who launched the book initially, to give us a bit of that history. Hi, Mike. And can you tell us about how you started this volume?
Thanks very much, Jody. So in 2005, I had just finished my term as chair of the ABA's section of Environment, Energy, and Resources, and I decided that the next book I should do, I'd done several before, should be on climate change, since there weren't at that time any books that summarized the U.S. legal situation with respect to climate change. So I put together a bunch of authors, and the book came out in 2007, published by ABA Publishing. Rather than do a pocket part for updates, we decided to create a website which would have new cases that emerged that were relevant to the topic. And that was the origins of our very large climate change litigation database, which has expanded considerably, is now international, and is widely used. A few years later, it became clear that the book was already outdated. When we wrote it, we thought that we were about to have legislation, the Waxman-Markey bill. That didn't happen. So it was time for a second edition. I brought in Jody Freedman as my co-editor for the second edition. And a few years later, it was outdated again. And Jody and I decided to bring in Mike Berger as our third co-editor. So we now have the third edition of this book, and it is still the only really comprehensive book about the U.S. laws relevant to climate change.
What I love about the book, Mike, is how comprehensive it is. And I was excited to join. I was honored to be asked to join you because I thought the vision for the volume was so interesting. It's not just about greenhouse gas regulation rules, right? It's not just the Clean Air Act. It covers so much more ground. It covers the international scene. It covers state and local regulation, but it also covers things like how adaptation has evolved, how the law of adaptation's evolved. It covers disclosure, corporate disclosure rules, and it covers new technologies like direct air capture and CCS. It's really got a 360-degree view of how we in the United States are dealing with climate regulation and response. So I was really excited about that feature, and I think this new edition is even more comprehensive than past versions. Do you agree with that?
Yes, and in 2007, when the first edition came out, the U.S. had zero laws explicitly about greenhouse gases. We now have a few, but most of the laws that are relevant to climate change are not explicitly about climate change. They are about energy and transportation and land use and many other things that directly affect climate change. So we've tried to bring into the book not only the small number of laws that are explicitly about climate change, but the larger number that really affect what happens with climate change.
And Mike Berger, let me turn to you now. You are our latest co-author. So can you give us a sense of what you thought when you agreed to join the book and how the experience has been on this third edition?
I think the first thing I thought, Jody, is what an amazing opportunity to work with Mike, who I get to work with, every day at the Sabin Center, and then also what a great opportunity to get to work with you. So that was thought number one. Then I thought about the book itself, which is, I think, a touch point for many of the people involved in the climate change law field. It's a desktop reference for everyone, right? This is a book that is for lawyers on all sides of any issue. It's for researchers at all levels, from high school, I would say, on up. And the approach it takes is compelling to me. It's explanatory, it's comprehensive, and it's accessible. The book doesn't try to make any one particular point or present any one particular argument. It's a resource that others, lawyers, policymakers, staffers working behind the scenes, academics, It's a resource that they can use to try and make the points and arguments that they want to make. And I think that that's a tremendously valuable contribution to make to the field. I do want to say, I mean, that's not to say that the chapter authors don't have their perspectives. They absolutely do. And the episodes that we have here, I think, are a real opportunity to get to hear some of those perspectives in a bit more detail. But to a large extent in the book, the perspectives of the authors are in the background. They help frame the issues. They help shape the approach to the information and the material. But a reader's not really being asked to take on a particular viewpoint. And again, I think that working in academia, working on the margins of academia, working in the practitioner field, this really does provide a very unique and comprehensive bridge for anyone who's engaged in this work.
So we can imagine practitioners getting the benefit of this book. We can imagine law school classes on climate and energy getting the benefit of this book. We can imagine undergrads, right, using parts of the book. And you can, sort of use whatever chapters make the most sense. We have a really top flight slate of scholars and practitioners who participated in writing these chapters. Just a terrific set of experts. So it's a high quality, high value volume, I think. And this 3-part series, this podcast is really meant to highlight just a small set of our authors. We're kicking off our 3-part series with my conversation with Tom Lorenzen, who is formerly of the U.S. Department of Justice, now in private practice, and Jim Rossi, who is at Vanderbilt Law School. And Tom wrote the chapter on the Clean Air Act, which covers all the major greenhouse gas rules that EPA promulgates under that statute for every sector of the U.S. economy, including power sector, transportation sector, oil and gas sector. So that chapter is really important and foundational to the volume. And we're also talking to Jim Rossi about the energy sector, about how FERC and the states regulate electricity and the impact that has on climate change, which is so closely intertwined with electricity consumption and production. So those 2 chapters are super interesting. These guys are really great to talk to. And we also address in this first podcast how things have evolved even since we finished the volume. So we've seen the EPA and the Biden administration put out new rules, new greenhouse gas rules under the Clean Air Act, and we'll talk a little bit about that. So Mike Berger, who will you be talking to in your episode?
Well, I had a great time speaking with Sheila Foster and Alice Caswan. And Sheila is a professor who was at Georgetown at the School for Public Policy, but has joined us at Columbia and will be on the faculty at the Climate School at Columbia starting this summer. And Sheila is a leading voice in the field of environmental and climate justice, and with a real deep and extensive expertise and history in urban issues around climate change and environmental protection. And she authored the chapter on cities and local governments. Alice is a leading expert in the area of environmental and climate justice who's been writing about these issues for more than a quarter of a century. And she's based out at the University of San Francisco School of Law. And she contributed the chapter on climate justice. And so these 2 chapters really fit together nicely and I think do complement the other episodes in that these chapters are not specifically about regulation. They're really about issues that cut across all forms of regulation and climate action. And that would be the chapter on climate justice. And then what's happening at the local level, which, it's often said, and I say it's often said because I say it often, but many, many other people do as well. Cities have always been at the forefront of climate innovation, and they are very much on the front lines of climate change impacts. And what's happening at the local level here in the United States in addressing the climate crisis, both in terms of reducing emissions and getting off of fossil fuels, and in terms of adapting to climate impacts and protecting public health and in communities in a just and equitable way, is really, it's quite a story, and it's quite a compelling set of questions and issues that come up. And both Sheila and Alice are very much immersed in those areas. And it was great to have the chance to talk to them both about what's going on there.
Mike Gerrard, who are you going to be hosting on your session?
I'm going to be hosting Peter Lehner of Earth Justice, who's going to be talking about the role of agricultural systems in fighting climate change, and Tracy Hester of the University of Houston Law School, who's going to be talking about carbon capture and sequestration and carbon dioxide removal. One thing that ties these 2 together is that everyone recognizes that the single most important thing we can do to fight climate change is to transition away from fossil fuels and reduce greenhouse gas emissions. But that's not going to be enough. We need to modify our agricultural systems because they are themselves important sources of greenhouse gas emissions and have considerable potential to draw down carbon dioxide from the atmosphere. And we're going to need to capture the CO2 that is emitted from some hard-to-abate industrial sources that requires carbon capture and sequestration. And we're going to need to draw down a lot of the CO2 that is in the atmosphere. Some of this is through agriculture and natural solutions. Some of this is through more engineered devices. But these two talks by Tracy and Peter are going to tie together in that way.
This what I love is that, when I chat with Tom and with Jim, we're really talking more about regulation. And the other two chapters, what you're going to talk to your guests, are really less about regulation, right? And more about, as you say, other things we need to do besides rulemaking to control GHG. So it's a great 4 examples of 4 authors working on really important, really interesting topics.
On the issue of climate justice, we had a real question in front of us. Climate justice is an issue that cuts across every chapter in our book, and it's addressed in every chapter in our book. But it's also very much an independent and discrete set of actions at every level of government, and a discrete set of rules, and a discrete set of approaches to integrating justice and equity into the solutions to the climate crisis. We made a decision to include this separate chapter, and I think it holds up.
The one thing I want listeners to know is we're just having 3 episodes. We just did 3 episodes on this with 2 authors each. But of course, this is a 21 chapter volume with so much interesting material. So this really should just whet the appetite, give people a flavor of what the book covers, and hopefully will interest people in taking it up and using it in their classrooms or as a resource in their practice. So we look forward to all 3 episodes and hope you enjoy them.
Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources. SEER is a member organization whose mission is to foster the success of a diverse community of environmental, energy, and resources lawyers, advisors, law students, and decision makers, and provide a premier forum for the exchange of ideas and information.
Welcome to a session with Jim Rossi and Tom Lorenzen for our podcast on the 3rd edition of Global Climate Change and U.S. Law, a volume that has been published by the ABA and edited by me, Jody Freedman, Mike Gerrard, and Mike Berger. This is a comprehensive volume on climate change law and regulation, and today Jim and Tom are joining us because they have written 2 of the key chapters in the volume. Tom Lorenzen wrote the chapter on the Clean Air Act and greenhouse gas regulation, chiefly by EPA, and Jim Rossi wrote the chapter on energy regulation, which covers the regulation of the electricity sector, so important to climate change. So for today's discussion, I want to just welcome you 2. Thanks, Tom, and thanks, Jim, for joining us. And let me introduce you both, and then we'll get started on your giving us an overview of what you covered in your chapters. Tom Lorenzen is a partner at Crowell & Moring in Washington, D.C. He's the co-chair of the Environment and Natural Resources Practices Group at the firm, and he spent 16 years at the Department of Justice as, and I'll let you say your title, Tom, so that we all get it correct.
Assistant Section Chief for Petitions for Review, overseeing the docket of all challenges to EPA's rules in the Federal Courts of Appeal and the Supreme Court.
And in that role, Tom, you and I got a chance to work together back in the day in the Obama administration when I was in the White House and you were at DOJ. And maybe we can talk a little bit more about that when we get into the material you covered in your chapter. And Jim Rossi, is one of the nation's leading scholars of federal energy law and administrative law. He is a prolific scholar, written about every aspect of utility regulation, federalism, decarbonization, the economics of the electricity sector, the future of the grid. Jim is a co-author of a leading casebook called Energy, Economics, and the Environment. He is the Judge D.L. Lansdowne Chair in Law at Vanderbilt Law School. And he, of course, we know each other for many years now, right, Jim? And you were a visiting professor at HLS, among other places. Welcome, and thank you both again for being here.
Thanks.
So let me start with you, Tom. I want to talk a little bit about your chapter and how you shaped it up and what you thought was important to cover. Can you give us a kind of summary of your contribution to the book?
I'd be delighted to. What we try to do in Chapter 4 of this text is take people through the history of regulation of greenhouse gases under the Clean Air Act, starting with Massachusetts versus EPA, the seminal case from the Supreme Court saying that EPA has the authority to regulate greenhouse gases under the Act, taking it up through American Electric Power Company versus Connecticut, in which the court held that federal common law claims regarding greenhouse gas emissions are basically displaced by that federal regulation, and continuing on through Utility Air Regulatory Group versus the EPA, which was the court's review of the first suite of greenhouse gas regulations, which Jody and I worked on together, where the court began to place some limits on that authority. We then talk about the various types of regulations that are in existence today under the Clean Air Act. Mobile source regulations for light and heavy duty vehicles, aircraft. We talk about stationary source regulations, such as new source review, the Section 111 new source performance standard rules, which have been the source of the Clean Power Plan, the ACE rule, and the expected spring rule on power plant greenhouse gas emissions. We talk about the West Virginia versus EPA case in the Supreme Court's enunciation 2 terms ago of this new major questions doctrine, which could have a substantial impact on EPA's ability to regulate going forward. And we talk about some other types of regulation of hydrofluorocarbons, regulation methane, and we talk about other options for regulating greenhouse gases under the Act, such as regulating them as criteria pollutants under the National Ambient Air Quality Standards Program, regulating them as hazardous air pollutants under Section 112, and even regulating them as sort of international pollutants under Section 115, a section of the Act that's been rarely deployed but is out there.
So, Tom, I think the key word in all this is regulation. And what you've described is really a series of Supreme Court cases that progressively seem to have cabined EPA's ability to use the Clean Air Act in the sort of maximalist way that the agency might want to, at least in Democratic administrations. You talked about the landmark case, Massachusetts versus EPA, and then all the way through the landmark case, West Virginia. And I just wanted to give listeners a sense of that progression. You know, it's really a progression in the court's approach to the Clean Air Act as a tool of climate regulation. Can you say something about how that's evolved, about the direction the court has gone in?
Sure. And I think it is a view of the court that has changed as the makeup of the court has changed, as we've all seen. It really did start out with a fairly maximalist view under Massachusetts versus EPA that said greenhouse gases are pollutants. They are regulatable by EPA because they affect welfare, and welfare is defined in the Act specifically to include effects on climate and weather. And so from there, I think EPA took things and tried to implement the Act according to the court's instructions. And then we started to see a shift in the court's makeup and the emergence of the conservative wing of the court saying, let's think about this more carefully. It is not a carte blanche authority to regulate greenhouse gases. It's more limited. You need to look at each statutory provision, determine whether that provision actually makes sense for regulating greenhouse gases. And that was where we stood at the end of the American Electric Power and Utility Air Regulatory Group cases. Then West Virginia really sort of shook people up because it said, when something is a major question, that is something that's going to have a potentially profound effect on the economy or is sort of a very novel approach to interpretation of the law, we're going to look skeptically at that and really rein in the agency's authority. So now, as the agency grapples with how it regulates greenhouse gases in this upcoming rule and upcoming rules, EPA has to grapple with, is it employing the act in a traditional manner? Is it employing the act to forcibly shift generation from one type of source of power to another, such as from fossil fuels to renewables? Or is it really imposing technology-based limits on what plants can emit, which seems to be more permissible?
So let me stop you there, because in giving that example, you're really referring to one rule that EPA has been designing and redesigning ever since the Obama administration, which is the rule to control greenhouse gases or carbon pollution, really, from the power sector. And that, of course, is the topic of Jim's chapter. So we'll go there in a moment to describe what he covered. But just so the listeners understand, Tom, you're talking about how EPA uses the Clean Air Act to regulate the key sectors of the economy that are responsible for the majority of greenhouse gas emissions. Because under that law, they have various statutory authorities that they could use to regulate, say, the transport sector, emissions from cars and trucks and planes. And they also have separate authority to regulate factories and firms that are stationary sources that produce GHGs from, say, the power plants in the country or steel mills in the country. And so once one understands how the Clean Air Act operates through these different programs, we see, Tom, that EPA has the authority to control emissions from all of the key sectors. Is that accurate? Am I describing that in an essentially correct way?
That is the way it should be described. Yes, EPA has various authorities that apply to mobile sources, stationary sources, and then to certain types of pollutants that are more hazardous than others. And we have to consider as well international law. There are international treaties that call for the phase down of hydrofluorocarbons, which are not only ozone layer depleters, but are potent greenhouse gases. And EPA has been using that authority to draw down the manufacturing and use of those very potent greenhouse gases. So yes, it is a multi-sector approach. The EPA has to proceed carefully in light of the Supreme Court's skepticism of broad agency authority when it's attempting to regulate each of these areas.
So that's really the story of the chapter. And for me, the story of your chapter, which, by the way, I was remiss. I should mention that you do have some co-authors who helped you. Robert Myers, Amanda Schaefer-Berman, and Elizabeth Dawson helped you out with this chapter. But for me, the takeaway from this chapter is you really get an overview of how the EPA uses the traditional 1970 Clean Air Act, which was, of course, amended a couple of times, most recently 1990. But they're using a relatively old law to address climate change. And they're bumping up against the Supreme Court's unwillingness to let EPA use it to maximum effect. I think that's sort of the way I read the theme that sort of pervades the chapter. Is that a fair reading?
It is a very fair reading. And I think one of the things you can read from this is a real call for congressional action to address climate change and greenhouse gases more specifically, because that seems to be what the Supreme Court is demanding these days.
So that's a great summary. And we should also say that these events are all continuing to unfold, right? When we published the chapter and the book came out about a year ago, we were in a place of, I will just call it under construction. Several rules were under construction. They were in the course of being proposed, weren't yet final under the Clean Air Act. It was the Biden administration's redo, let's say, of Obama-era regulatory standards that Trump had rolled back. President Trump's EPA had essentially rolled back each of these major regulations, and the Biden administration was in the early stages of putting those more demanding rules back in place. So, Tom, before I turn to Jim, can you give us a quick summary of where we are on these major rules now, 1 year later after the volume's been published? I know that we have a transport sector rule for auto efficiency standards that's in progress. We have a methane rule that recently went final. Can you give us a quick summary of where we're at?
Yes. The methane rule, in fact, is expected to be published in the Federal Register on March 8th. We expect very shortly to see the light-duty motor vehicle rule, which is going to further that push towards EVs, and we're hearing some political pushback against that. And we know that President Biden is considering whether to push that as hard. But nonetheless, we expect to see that soon. The power plant sector rule we expect will be out in April, and then we'll see similar litigation over each of these rules that we saw during the prior administration. So we have rules coming out shortly, and then expect to see lots of people in court for another year to two as they hammer these things out.
Yeah, and the other thing to note is all of these rules are being finalized relatively soon in this spring of 2024, let's say, partly because we're in an election year and you have to play a little bit of defense when you're the administration in an election year. You don't want to adopt rules so late in the year that there's an opportunity for a new, potentially different president to come in, and the Congress will have the opportunity then to basically disapprove these rules by reaching back using the Congressional Review Act, which is a law that lets them disapprove rules that were finished within about a 6-month period, right? Kind of retroactively reject those rules. So there's sort of a cutoff in mind there where you have to get your rules finalized and out before the deadline. Is that about right, Tom? I've oversimplified the Congressional Review Act, but that's about right.
No, you've not oversimplified it. That is correct, but there is a second thing you need to think about as well. The Congressional Review Act is a quick and easy way for Congress with a cooperative president to undo rules that it no longer likes. But even absent congressional invocation of the Review Act, a new president can halt rules that are in progress or over which litigation is pending, undertaking new rulemaking to undo those and completely reverse course. This is what we saw in the transition from President Obama to President Trump. We saw it again in the transition from President Trump to President Biden. The big question is, will we see it again in 2025? That depends on who wins the election.
Yeah, I mean, the story of your chapter, and I think Jim will talk about yours next, but the story of both these chapters, and in fact of the whole volume, in a sense, is of a kind of pendulum swing from administration to administration when we're talking about federal rules. And when we talk about state and local policies, those too can be unstable, depending on whether governors change over and local governments change over. So the stability or instability of climate regulation, I think, is one of the themes of the whole volume. And this problem is such a big and enduring problem that it needs permanent solutions, consistent solutions. And one of the stories of U.S. politics and U.S. law is that we don't always have that kind of stability. Jim, let me finally turn to you and give you a chance to give us an overview of your chapter. I should mention you wrote it with Hannah Wiseman as your co-author. And this is really about, I think you called the electricity sector the epicenter of U.S. efforts to limit carbon pollution. Tell us something about why the energy sector belongs in a climate book, which is really what this book is about. Why is regulating the energy sector so important?
Well, yeah, I mean, there's the energy sector as a whole, which arguably includes part of transportation. And then there's the subject of our chapter, which is focused primarily on electricity regulation in particular. And, transportation leads the sectors with respect to carbon emissions. Electricity isn't far behind in terms of carbon impacts. And the electric power system has been described by engineers as the largest and most complex machine ever made. Our chapter really focuses on the myriad of ways that U.S. law regulates it and its implications for climate change. So we begin by providing a description of the various sources of supply of electric power, as well as the demand of electric power. We describe in particular the transition that's occurred over the past decade from a coal-dominated power grid to a grid in which natural gas and renewable energy in particular dominate as sources of energy. They're more than 60% of the power sources going into the grid today. We then move on to discuss some of the traditional ways that the electric power sector has been regulated, in particular the idea of traditional rate regulation of regulated electric utilities, mostly by states, as well as the role of the Federal Energy Regulatory Commission, or the Federal Power Act. FERC has adopted policies to promote competitive markets for wholesale power supply. It adopted those policies first in the 90s, and it's continued to expand those policies It is continuing to expand them today. After introducing this background, we move on to survey a number of low-carbon laws and regulations for the electric power system. On the supply side, we focus on financing assistance, such as subsidies or tax credits for clean energy development. We discuss low-carbon mandates, such as renewable portfolio or clean energy standards, and we discuss efforts to reform siting and permitting at both the federal and state levels. We also discuss the promotion of new technologies such as storage and some of the regulatory challenges related to expanding the transmission grid. And on the demand side, we discuss things like appliance and building efficiency standards, efforts to shift demand through managing retail customer rates, and policies aimed at promoting demand reduction and conservation.
And one of the things that strikes me, and one of the nice things about having you and Tom together in this discussion is, while at the federal level, we see EPA operating under the Clean Air Act, and EPA is playing its role as a pollution regulator, at the federal level in your domain, we see FERC operating to regulate wholesale electricity markets and also transmission across state lines. It has a very specific purview, FERC does, under the Federal Power Act and a particular mandate, and it's quite different than the EPA. So it's nice to juxtapose these two chapters. And can you say something about that, Jim? I mean, the traditional role of FERC has nothing to do with climate change, right? Or it doesn't see itself as an environmental agency, right? But it's become so important to climate change. Can you tell us why?
Sure, certainly. And, as you point out, this is not unlimited jurisdiction with respect to the Federal Energy Regulatory Commission. Wholesale electric power markets and the transmission grid are primarily regulated by FERC under Part 2 of the Federal Power Act. FERC's historical role here was as an economic regulator. It was focused on ensuring that utilities had a sufficient rate of return to keep the lights on, while simultaneously keeping customer rates low, right? On the other side of the jurisdictional split, you've got the states. They regulate the sale of electricity to the end-use customer, what are called retail transactions. And states also determine the policies regarding the balance of resources in the power supply portfolio. FERC doesn't get to pick which resources become predominant. It's focused more on economic issues, including market design today. And that has important implications for how FERC understands its role. I think it can definitely complement climate policies. It can definitely enable climate policies, but it doesn't seem to be the one taking the lead with articulating those policies in most instances. Instead, it seems to be playing more of a role of market gatekeeper and referee.
And I think one of the themes that comes through loud and clear from your chapter is this balance of state and federal power in the electricity sector and the way in which the states are really determining the climate agenda for the energy sector, for the electricity sector, by adopting policies like, let's say, California and a whole variety of other states adopting renewable portfolio standards that are really about making sure, I think, Jim, you'll correct me if I'm wrong, making sure that some increasingly larger share of electricity delivered to consumers in the state is renewable power or something defined as not fossil energy. And in that sense, the states are driving climate policy forward. But we have FERC there lurking over them, and FERC can either interfere with those policies that states are driving, or FERC can sort of move them along, nudge them along, or encourage them. Is that a fair way to describe the FERC-state interaction in this space?
Yeah, I think there's a little bit of push and pull there, as you describe, though I think FERC historically has viewed its role as being complementary to state regulation. And part of what it's trying to now define is how it understands that complementary role in light of its market policies, given that states have different kinds of climate goals that they're trying to pursue. So, a lot of this is how do we integrate or acclimate the state policies into these wholesale markets that are designed by FERC and managed by FERC.
And the wholesale markets are really about all that. When we say FERC's traditionally been an economic regulator, we're really talking about making sure electricity rates aren't too high for consumers, right? Trying to protect consumers from monopoly power historically, trying to make sure electricity is plentiful and cheap and reliable, right? That's the mission FERC has always had. But now we have this new climate imperative, and it's somehow isn't it affecting FERC's mission, or does that depend on, say, the composition of the agency and whom the president appoints and Congress confirms to be a member of the commission? Can you say something about that? Because it's quite different than EPA. And again, that's another reason why it's nice to have your chapter juxtaposed with Tom's. EPA is a traditional cabinet level agency now. President names the administrator. There's one administrator. They pretty much answer to the president. You can expect the EPA to carry out, by and large, the policy prerogatives of whatever president's in power, whatever administration's in power, subject, of course, to what the law allows. But FERC, well, it's a little different. So can you say something about that? Because your chapter conveys this very clearly.
Yeah, no, and that's a really fascinating set of questions that you've raised here. And, at the outset, as you pointed out, this is a commission by its nature, right? So it's a multi-member agency. No more than 3 of its 5 members can come from the same political party. That imposes a natural institutional limit on FERC's ability to effectuate significant policy shifts, just as a president changes, for example. At the same time, if you look at the Federal Power Act, FERC is delegated the authority to apply a very broad statutory mandate, right? It sets just and reasonable rates, and it protects consumers against discriminatory pricing in power markets. On its face, this would appear to give the agency wide latitude to change policies to fit the climate preferences of a president. So you've got some things that point in different directions here. If you look at what FERC actually does in its regulatory mission, though, I would argue that FERC tends to be much more incremental and less responsive to the policy preferences of presidents. If you look at the design of the Federal Power Act, for example, this places FERC primarily in a reactive rather than a proactive position with respect to most big policy changes involving the electric power industry, including those concerning climate policy. By and large, FERC responds to tariff filings by the utilities it regulates. And that means FERC cannot just unilaterally announce a big policy change without first making the kinds of factual findings that it needs to make under the statute to determine that existing practices or pricing by utilities and power markets are unjust or unreasonable or discriminatory. And if you look over time at what FERC does, its main regulatory approach has tended to be pretty consistent and very incremental with respect to climate policy. It's responding to industry requests by and large. If, for example, a new technology feels it's being discriminated against in wholesale pricing practices.
Like wind or solar, like just to interject,
exactly.
The whole idea is to make it possible to make the market for electricity more competitive. And if wind and solar power is cheaper, you want to make sure it's not discriminated against, right? You want to make sure it gets to compete in the market for electricity generation. Is that how it works?
That's right. You want to ensure that there are not discriminatory barriers to these kinds of resources competing, right, in the wholesale market, right? That the incumbents are not placing barriers on their ability to offer that source of energy as an alternative to what might be the predominant sources of energy that are managed by the incumbents. So we're trying to regulate the monopoly power of the utilities that often own both generation and transmission in the interstate market.
That brings up transmission. And then I want to get back to Tom in a minute to talk about the difference between EPA and what goes on in the electricity sector. But before I do that, transmission. There's a lot of great stuff in your chapter about the challenge of siting transmission. And can you say something about why that's so important to climate policies, siting and paying for new transmission?
Yeah, it's certainly important to climate policies because to enable new resources in many parts of the country, we need to have sufficient capacity on the grid. We need to have access to the grid, and we need to have the capacity on the grid. And that includes the ability to interconnect with the grid in many instances. That's one of the big challenges that many new generation technologies, including wind generation and solar generation technologies, are facing in many areas of the country. So we're going to have to build new transmission lines. We're going to have to build them in new areas, and we're going to have to expand much of existing transmission infrastructure. And that's going to require siting approvals by states. The regulatory approach here is to place the siting of these transmission lines with state regulators currently. And that means effectively, we won't see the expansion here until state regulators approve those lines going across state borders. And, that's very important because many states are states with land resources that are necessary to allow the lines to expand for purposes of enabling additional resources to compete in markets in the grid and to also offer energy at lower carbon than incumbent resources.
So one of the takeaways from your chapter, I think, is be on the lookout for new challenges around transmission. And if you can't get the transmission in place, you can't get new resources like solar and wind power into the grid, right, Jim? And you can't get it to the demand centers, to the load centers. So it's fascinating because your chapter covers some of the really important regulatory and decisional challenges we face in trying to modernize the grid and decarbonize the grid. And you cover both the federal role and the state role and how they interact in that process.
Yes. And I'm afraid we only scratched the surface.
Right.
But we do, I think, attempt to survey those issues. And as you're pointing out, those issues are real challenges. They're quite complex. And we don't yet know the answers to many of these questions. Many of these questions will likely depend on what Congress does in the future with permitting reform. In addition, there are pending issues about how FERC will approach the issue of transmission planning at the regional level.
And how to encourage it and not interfere with, but encourage the states and regional transmission organizations to do it, right?
That's precisely right. Instead of, the real natural tendency in certain states is for the incumbent utilities that own the transmission lines to drag their feet on expanding transmission.
And why is that? Just quickly, well, why is that? Because, when you get into your chapter, you get a better answer to this, but what's the problem here? Why don't they want to build transmission?
Yeah, I think it has to deal with the complex mission of many modern utilities and organized markets. On the one hand, many utilities are serving their incumbent customers, and they want to ensure that they provide reliable, low-cost energy at retail to their customers. On the other hand, many of these utilities are players in interstate markets, so they're very dependent on the interstate market. And, some of them have missions that coincide, right, and converge with respect to these goals, but at times there's a bit of a tension. And often the in-state interests, right, of keeping rates low, protecting incumbent customers, and sometimes even allowing your incumbent sources of energy, your existing power generators, to have a good rate of return on their assets. Those incentives might work at crosswinds with incentives to expand the grid to promote more interstate competition and additional sources of energy.
So one of the things you both talked about, Tom, now coming back to you, is the need for Congress to play a role in both in pollution regulation, which is the traditional domain of the EPA, and pollution regulation is really how we get at reducing GHGs in the economy, right? Like, Tom, the role of EPA using the Clean Air Act is all about trying to produce fewer emissions, which, of course, is necessary if the U.S. is going to meet its own climate commitments to the Paris Agreement. But the road to doing that goes through Jim's chapter, if you will. The road to doing that, if you're going to electrify the transportation sector by promoting electric vehicles, if you're going to reduce GHG emissions in the production of all of our materials like steel, et cetera, and if you're going to try to decarbonize buildings, for example, you have to electrify all of these other sectors to a very significant extent. If you're going to electrify them, you go back to the grid. You go back to the U.S. electricity grid and the electricity sector and the sources of electric power. And if you don't green up the provision of electricity, you can't achieve your climate goals, right? So if you have a dirty grid, not a green grid, you won't accomplish your climate goals. So in this sense, Tom, the imperative of your chapter and Jim, the coverage of your chapter intersect. Tom, can you give us just a little bit of a sense of how you see that from your perspective?
Well, I think that, Jim makes some really valid points, and it's not just about transmission. It's about the need for infrastructure, for greening of the power sector generally. We not only need those updated transmission grids, we need, for instance, just taking the new power plant rules that we're expecting this spring. They rely on a couple of emerging technologies, developing technologies, to reduce those emissions of greenhouse gases from power generation. Those technologies are carbon capture and sequestration and low carbon hydrogen as an alternative fuel to natural gas. Each of those requires massive investments in infrastructure. To do carbon capture and sequestration, you have to be able to transport that carbon dioxide from the power plants to the geologic formations where they can be injected and stored. Those formations do not exist everywhere in the country, so you have to create a massive system of pipelines to transport that greenhouse gas to those locations. Low carbon hydrogen is a new fuel. The existing pipelines that transport natural gas aren't really suited to transporting low carbon hydrogen around the country. So if you really want to roll that out as a power source, and you have to build or upgrade your pipeline system for transporting that fuel. So it's all interconnected. And as you said, if everyone's switching over to EVs, you get your emission reductions only if you are decarbonizing the power sector generally. So you need to make provision for reducing carbon emissions from fossil fuel-fired power to the extent it's still going to be the core of our energy, or even a backup. And you need to provide the transmission access to the new green power sources like wind and solar. And there are disincentives to the power companies to provide that transmission access. Many of these power companies not only own the transmission, but they have relationships, contractual, corporate, or otherwise, with those who generate the power. And there is an incentive for them to preserve their existing power generation sources, which means trying to freeze out those who want to get in otherwise, those new generators.
So these two chapters cover, you can just get a flavor of it, right? Cover so much wonderful detail about the key agencies involved in climate regulation, both the federal level and the state level that you have to understand, litigation around all of these issues. You guys cover that in your chapter. The importance of the Supreme Court, especially the cases under the Clean Air Act, but also, Jim, in your domain, the Supreme Court still looms large. It may or may not have approved of the state approaches to demand response, right? It may or may not have, if FERC were to act in a way that interferes with, say, net metering or some other policy, the Supreme Court could come and decide whether FERC has or doesn't have the authority. So in both of these chapters, the Supreme Court and understanding its role and what it might or might not do is very significant. And both of you also talk about Congress and the role Congress plays, the crucial role it plays in setting climate and energy policy. Jim, let me just flip back to you before we close and say, is the Supreme Court playing as important a role right now and is Congress playing as important a role right now as Tom described when he talks about EPA's ability to implement the Clean Air Act and Congress's failure to pass an update to the Clean Air Act? What's happening in the field of electricity law?
Sure. Well, in the field of electricity law, I think the challenges are a little bit different because if you look at FERC's role over time, it's been quite stable, and it's been quite stable across presidential administrations. That's not to say there are slight differences in preferences there, but you don't see shifts. You don't see substantial shifts where FERC policies may be adopted in one administration and reversed in a later administration. We just haven't seen that sort of change. And some of that is perhaps because this is a heavily regulated industry and you get significant industry buy-in in the policy, and then the costs of reversing it become so high. I'm just not aware of FERC ever making a declaration in response to a presidential directive or in a manner that's been adopted and then modified or reversed based on the change in presidential administration. It tends to be much more incremental and gradual. And in that sense, this is perhaps the kind of stability we need in the regulatory order. As long as we can get the right policy direction and the right policies in place, we may be able to get the stability in the context of an agency like FERC that perhaps is more difficult to obtain in other regulatory contexts. So I'm optimistic. At the same time, I think we have some challenges here. One challenge is the federalism divide you've mentioned, and permitting in particular is going to be a big challenge here as you move to new technologies like hydrogen and CCS, as Tom mentioned. And the other challenge we're facing with FERC right now is a multi-member agency. We're having trouble getting beyond 3 members, and we might even be down to 2 this summer. So getting those new appointments announced and through the confirmation process is going to be very, very important to have an agency that can effectively make the kind of policies we need.
So last thing I want to ask you guys took time out of your busy schedules. Tom, you're practicing law. Jim, you're teaching and writing and heavily involved in policy in addition to your scholarship. You guys are really busy. Tell me why, it's important. I think a volume like this that puts together an overview of everything we see in U.S. domestic law and regulation on climate change is a really important volume to put together. That's why we editors decided to do it. But tell me something about, what can lawyers learn from this? Is this a primer? Can students learn from this? Why were you happy to contribute? You did us a great favor in being contributing authors, but tell us something about why it's important from your perspective. Jim.
Certainly. I think in part because of the complexities, we only scratch the surface in describing in this chapter. We hope that lawyers can take a message from this. Key lawyers working in this arena to be effective in representing their clients, they need to have an understanding of energy markets and their regulation by FERC. And they also have to have an understanding of an appreciation for state policies and the challenges that are presented by the decentralized, often fragmented approach to climate policy that we see in the electricity sector. I don't have answers to all the questions that come up here, but the complexities here really require some understanding of the institutions and certainly what those institutions can do, but also the limits of the authority that many of those institutions face in these arenas.
Yes, so true. And Tom, how do you see it from your perspective, writing your chapter?
Well, to me, the reason I contributed to this book is climate change is perhaps the defining issue of our generation and the next. How we address it, whether we can address it meaningfully, is going to define the next century and more. Understanding the tools and levers that the government can deploy to affect that change requires an examination of the history of climate regulation and how the courts have treated it, an examination of how the Supreme Court is changing with these new doctrines of administrative law that limit federal agency authority, and a real understanding of why congressional action might be so necessary. What we've seen in the past is that when Congress has addressed specific environmental problems through specific provisions directed at them. Let's take Title IV of the Clean Air Act, which addressed acid rain. That was a very effective program, and it has worked wonders for the forests of our nation. We need something similar for climate change because, as you noted, Jody, Congress right now has not amended the Clean Air Act since 1990. That is more than 30 years. We are using a very outdated tool to try to address a very novel and challenging problem. We need something specific. So this chapter, I hope, will give people an understanding of how we got here and what tools are available going forward and what additional tools might be needed.
So I couldn't have said anything better myself. You guys did a great job on the chapters. You did a great job here describing what you covered. I'll just say, we're going to have a 4th edition. I hope you'll come back and write for us. this is such a still fast-moving field, climate regulation, climate law and policy, and the interaction of climate and energy law and policy, which Jim, you and Tom together have really covered the way in which it interacts, electricity policy, for example, and Clean Air Act regulation. This is going to keep evolving. Congress has done one or two big things, right? It passed an infrastructure bill and it passed the Inflation Reduction Act, which is chock full of incentives and subsidies to try to move clean energy to market. That's very different, right, Tom, from updating the Clean Air Act and saying, here's a regime for reducing greenhouse gases. Congress has not done that piece. It could, a different Congress, it would have to be a very different Congress, but a very different Congress could impose a new regulatory regime. But what it's chosen to do instead, I guess we would call industrial policy is what we'd call it, a bunch of subsidies and incentives. You guys both included some of that in your chapters. I included it in the final chapter of the volume, sort of a summary of all the things Congress has not done and a summary of all the things Congress has done. And we'll have to stay tuned for the next edition to see how things change. But thank you so much for providing such a terrific snapshot of your contributions to the book. And I really appreciate seeing you guys. I hope I get to see you in person soon. Thank you both.
Thank you, Jody.
Thank you.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.